Well, you'll have to file all your motions in writing, and then you serve them as well on the prosecuting attorney, and then we'll set motion hearings.
I don't have the resources to do that in custody, man.
I think you do.
I don't. There's not much paper here. There's no computers I can use, no printers.
This courtroom hearing takes a dramatic turn when Mr. Valentine decides he wants to represent himself and makes it clear almost immediately that he does not trust the court or anyone appointed to represent him. The judge explains that an experienced criminal defense attorney is available, but Valentine declines and says he believes he can better protect his own interests. That decision becomes especially important because the state is already asking the court to keep him in custody and impose substantial bail. According to the prosecutor, Valentine has a significant history of failing to appear, and the court had previously issued $15,000 warrants on each of 2 cases. The underlying allegations include 2 DUIs, one from 2021 and another from 2024, with the prosecutor noting a reported breath result of 14 in one matter and a refusal allegation in the other. But then Valentine begins challenging the very foundation of the proceedings. He says he is not a legal entity, describes himself as a living man, argues that he has a constitutional right to drive without a license, and asks the prosecutor to produce a contract proving the court's authority over him. The judge isn't persuaded. Instead, the court imposes $15,000 cash or bond on each case, along with strict conditions involving sobriety monitoring, court appearances, and driving privileges, and this is where things get even more intense. Valentine continues questioning the court's jurisdiction and whether the judge is treating him as a person. The judge eventually tells him something very blunt: the law does not agree with his interpretation. Stay with this one, because the courtroom exchange gets increasingly confrontational.
Your Honor, this is Mr. Valentine, whose matters, I believe, are at the end of the calendar, numbers 26, 27, and he has declined counsel and would like to proceed on his own. I believe my office had been this matter before.
Yeah, Mr. Valentine, you had an attorney appointed, and then you didn't come back the way we needed to come back way back in March. So you got an attorney sitting there, an experienced criminal defense attorney might help you. Would you like to take the advantage of having Thurston County Public Defense represent you again?
No, ma'am.
Can you tell me why?
Because I would like to proceed sui juris, because I believe I have my best interests, and I don't think anyone else in this court has my best interests for me.
Okay. All right. Well, first, there are a couple of warrants. I'm going to turn to the prosecuting attorney, Mr. Abid, first, and see what their recommendation is on this warrant return, and then I'll turn to you. So I'll just allow you to represent yourself today as you want to. Mr. Abid?
Your Honor, the state would object to releasing Mr. Valentine, and the alternative, the state asks that the court set substantial bail on both of these matters. The first one, ending in the cause number 693, is a case, is an old case. Mr. Valentine, I'm seeing, has substantial failure to appear history. This is here's sorry, Your Honor. Mr. Valentine was on warrant status for a significant period of time. In March, the court issued a $15,000 warrant on each case. The court, Your Honor, or the state, Your Honor, asks that the court impose bail in the same amount as the warrants.
And this is first DUI from November of 2021, and then the second allegation, January of 2024.
Correct.
And were these, one, it appears, was an allegation of a breath sample of 0.14, and the other from 2024, do you know the allegation?
My notes show that the 2024 allegation was included a refusal.
Okay. All right. So, Mr. Valentine, what the state's asking me to do is have you post about $30,000 cash or a bond bail, and consider those same restrictions that were on you before, that you show up at pretrial services, that you stay clean and sober, you stay law-abiding, you give UAs, you be on a device that's attached to your person to make sure you're not consuming alcohol. What do you have to say?
I object to that, Your Honor. I did make my best effort to show up at court, even when I didn't show up because I was confused about the dates. The clerk told me the wrong date. I showed up. I gave the clerk a letter. I wrote a letter to the court, and I also wrote counterclaims and responses to the State Attorney General's office, and I got no response from either. I went to try to squash the warrant. They told me that they wouldn't squash the warrant. They wanted me to either turn myself in or they wanted to get me to pay more bonds. I have absolutely no problem showing up and representing myself. As far as, what was the next thing? As far as these charges that are against me, I wanted to be clear that I am not a person. I'm not a legal entity. I'm a living man, and I want to enforce my constitutional rights. I have the right to drive without a license. I don't need a license. The Supreme Court has proven that many times. And it is also my understanding that this is a Nisi Prius court, and I would like to implement Rule Nisi. If the prosecutor has a valid contract between us, I would like him to produce it. If not, I do not wish to contract with any members of this court.
Mr. Valentine, I'm going to hold you on $15,000 cash or bond bail on each of these independently. So you'd have to post bond to be released, as I find that you're a risk to reoffend and a risk to commit, another DUI or vehicular assault or homicide, given the history, while under the influence. So you're a danger to the community is what I'm finding. And you don't come back when we order you to come back, and you don't comply with court orders. So $15,000 cash or bond has to be posted on each one of these separately. And then you have to get yourself into pretrial services within 48 hours of release and have a scram device attached, stay clean and sober, stay law abiding, in order to stay out of custody. No alcohol, no marijuana, no non-prescribed drugs, no bars or taverns. And don't drive unless you have a good license and proof of insurance.
This is the critical legal moment in the hearing. The judge has now made the bail decision, and the numbers are significant. $15,000 cash or bond on each case, meaning the two matters are being treated independently for bail purposes. The judge also explains why the court believes stricter conditions are necessary. The court specifically identifies concerns about the risk of reoffending and the risk of another DUI or even more serious consequences based on the history described during the hearing. The judge also points to Valentine's previous failures to appear and his alleged failure to comply with court orders, and notice that the judge isn't simply saying, pay the money and leave. If released, Valentine would have to report to pretrial services within 48 hours, comply with sobriety monitoring, use a scram alcohol monitoring device, remain law-abiding, avoid alcohol, marijuana, and non-prescribed drugs, stay away from bars and taverns, and only drive with a valid license and proof of insurance. So the court is essentially balancing release against public safety and compliance concerns. The question for viewers is straightforward. Given the history described by the prosecutor and judge, do you think these conditions were reasonable, or was the court going too far?
I'm going to set another court date. We would do this.
What jurisdiction is this court operating under, Your Honor?
Thurston County District Court here in the state of Washington.
Or what jurisdiction are you trialing me under?
What jurisdiction? Thurston County District Court, Thurston County, state of Washington.
That's not, is this under a common law jurisdiction?
I'll have you research all that yourself, sir. I'm not going to argue with you. I have jurisdiction over you and over this matter.
So is this court operating common law, ma'am?
I'm talking to my clerk. 1 second. And make it clear, good, that he's proceeding pro se and that we need to do it.
I am not pro se. I'm sui juris.
All right. You're proceeding without an attorney.
Did you take an oath to uphold the Constitution of the United States, ma'am? The Supreme law of the
I
land?
sure did. I take it every time I get reelected, and I take it very seriously.
Will you be honoring that?
Very seriously.
Are you going to be honoring that
No,
oath
it's
today,
just
ma'am?
pre-trial, and then we'll get it set for confirmation and jury dates.
Are you honoring that oath today, ma'am?
I sure am. And I do it every day.
So you think I'm a person?
I sure do.
So you think I can be bought and sold and regulated? You think I'm a persona, that I live in the likeness of another?
I think you're a human being and you're covered by the laws of the state of Washington.
A human being and a person are two different things.
No, I'm not interested in semantics. So
I'm trying to get down to the facts, ma'am.
you can define things the way you want, but the law is not agreeing with you. All right, we're going to be back on September 20th, 1:30. We'll probably talk some more about your decision to represent yourself, and that's fine. But don't be surprised if whichever judge is there has another discussion with you about that. And at any time, you can ask the court to appoint an attorney. Anytime you can hire an attorney to represent you too. You're not prevented from that. So we'll be back on September 20th, and you need to be back in court. If you're still in custody, we'll hear you in custody. And if you do postpone, you have an obligation to get into pretrial services within 48 hours and comply with them for sobriety monitoring. And that substance use monitoring program will pay for the Scram device.
Can we change the venue, ma'am, for lack of jurisdiction?
Well, you'll have to file all your motions in writing, and then you serve them as well on the prosecuting attorney, and then we'll set motion hearings.
I don't have the resources to do that in custody, ma'am.
I think you do.
I don't. There's not much paper here. There's no computers I can use, no printers. They're not giving me post
Offering you Thurston County Public Defense's assistance, I could.
Deny the right to defend myself. You want me to hire someone else to do it? I'm a sound
I'm
mind
not
body.
denying that, and I'm not going to argue with you, sir. So, at any time, we can talk about standby counsel, we can talk about counsel.
Everyone represented. I will continue to proceed sui juris.
All right, that's up to you. I'm doing that. All right, so we're done today, and those orders will be given to you in the jail.
All right, I don't consent to any of those orders.
And that's where this extraordinary courtroom exchange ends. Mr. Valentine chose to proceed without an attorney, despite the judge repeatedly explaining that experienced public defense representation was available. The state opposed his release and pointed to a history of failures to appear, along with 2 DUI-related matters. The court ultimately ordered $15,000 cash or bond on each case, while also imposing strict pretrial conditions designed to address the court's concerns about sobriety, compliance, and public safety. The most controversial part of the hearing, however, came from Valentine's arguments about legal status and jurisdiction. He repeatedly described himself as a living man rather than a legal entity, challenged the court's jurisdiction, questioned whether he was a person, and said he would proceed as a serial jurist. The judge rejected those arguments and made the court's position clear. He is a human being covered by Washington state law, and the court has jurisdiction over the matter. Importantly, the judge did not prevent him from changing course. The court repeatedly explained that he could request appointed counsel or hire an attorney at any time. The judge also explained that any formal motions regarding venue or jurisdiction would need to be filed in writing and properly served on the prosecutor. The next court date was set for September 20th at 1:30, with further discussion possible regarding his decision to represent himself. So what do you think? Was Valentine exercising his right to represent himself, or did refusing legal counsel make an already difficult situation even harder? Let us know your opinion in the comments. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments. And don't forget to subscribe for more jaw-dropping courtroom breakdowns.